Good morning, everyone. I welcome everyone to our s- lecture 2 of the Expert Talk series by Vidhi Varta. Today we have among us Professor Dr. Alok Verma. He is a well known name in academia. Presently, he is working as Associate Dean and Head of Legal Department at GLA University, Mathura. Before joining JLA University, he worked as a founding senior professor of law in Amity University, Noida. He possesses more than 18 years of experience in academics as well as industry. He has various published research papers, articles, chapters in books, as well as books to his credits. He is associated in the capacity of advisors as well as editorial team members with numerous national and international law journals. He has been invited as a guest expert by various reputed government and private institutions to talk on various legal and allied issues time to time. He has also presented more than 50 research papers in international and national conferences across the country. He has organized several national and international moot court, mock trial, MUN, debate, and similar competitions. He was invited by CISF headquarters to train officers on legal issues for POCSO training many times. He has been welcomed by different institutions and universities of national importance as resource persons for workshops on cybersecurity. His area of specialization are ADR, international commercial arbitration, international taxation, mediation, banking law, insurance laws, etc. These are the few achievements that I can mention, and there are many more of to Sir's credit. I welcome Sir to our expert talk, and thank you, Sir, for sparing your time on a Sunday morning for our participants. I welcome you, Sir.
Thank you, Dr. So thank you, Dr. Somi, and thank you, Vidhi Varta, for providing me this platform. First of all, let me take this opportunity to thanks and congratulate Vidhi Varta that you have started a wonderful series of lectures by inviting different people from academia and industry. And today, without wasting the time, I will start today's dispensation, which is relating to the dispute settlement in international space law. So, if I will start with a brief synopsis of my today's talk. So, my synopsis would include, first of all, the introduction to the topic, why we have chosen this topic, what are the need of this topic, what are the call of time for this topic, and what are the importance and relevance of this topic. Thereafter, we will move towards the basic framework of international space law, what are the different legislations are working, whether internationally or nationally, or what are the different framework which are behind to enforce the peace into the space and for human and mankind's betterment, what kind of legislations are working for there. And thereafter we will use, because when we are talking about the legislation and different international space law, then first of all, thereafter, I would like to discuss about what are the various factors which are causing the disputes in international space law, because without knowing that, we can't move towards the remedies. So different factors we will be going to use. And after that, we'll discuss about the need of international dispute resolution mechanism. What are the different international resolution mechanisms which are available right now, even after having the different legislation and different tools for dealing with such kind of very important issues. And after that, we will use some alternative dispute settlement mechanism, and we will focus about what kind of ADR mechanism, like different mechanism. I'm not giving the name right now. We'll talk in the later on. And after that, I would sum up all my lectures, and thereafter I would wind up my lecture. So this would be the synopsis of today's lecture. So, ladies and gentlemen, let me start with the introduction of today's very important topic, because when we talk about this particular topic, so we have to start with the space age, and we can say that when we started the dawn of the space age in the 1957, when the Sputnik 1 was launched, so it was widely termed as the dawn of the space age that time. But until recently, outer space exploration almost exclusively remained a government activity. And that too, for just a handful of states were working on that. So it is only in the last 2 decades that a significant number of states have actively begun participating either independently or with support of other more capable states in various space operations. So today, outer space being res communis, the one term is used, that is the Latin term res communis, is being used by a large number of countries, and due to these developments and continuous research, outer space now hold the possibility of an era of activities for the benefit of mankind. So res communis is relating to the benefit of mankind, inter alia including satellite communications. So why we are using all these things? For the satellite communications, meteorological informations and protections, disaster management, environmental protections, remote sensing, navigation information, and space transportation and industrialization. These are the different area where this all these satellites and all these space activities are being used. So with the growth of, but we cannot say this, it is a dawn of the space age until and unless we find some more opportunities in the space activities. So with the growth of private entities, when the private entities entered into this space age, like SpaceX and Virgin Galactic, Cargo, and some other also available there for transportations, manned space flights, and even space tourism have become possible without much governmental intervention. We are now planning for the space tourism also. In my opinion, this is the real dawn of the space age, where the outer space activities have not just remained a fancy and mystical concept that lies in the government domain, but are rapidly becoming accessible to even private entities and individuals. So, in this regard, if we talk about the India's journey, because we are in our country, we must talk about the countries. So, India's tryst with outer space exploration began in 1960, and with the setting up of the Indian National Committee for Space Research, which we known as INCOSPAR, and it was founded by the under the leadership of Dr. Vikram Sarabhai, and Dr. APJ Kalam was also, who was the later on became the president of India, who was also a part of this initial team of engineers. Even Homi Jahangir Baba was also there. So these engineers and scientists founding the INCOSPAR. So in 1963, the committee launched a small sounding rocket to examine the upper atmosphere, which remarked the beginning of the space program in India. Thereafter, the Indian Space Research Organization ISRO came into being in 1969 in an effort to have a dedicated facility with all the necessary resources, spearheading the efforts of Indian government to make the nations fully capable of handling its own outer space activity. And now, if we talk about the India's contribution toward the space activity, then the first Indian satellite Aryabhat was, with the help of Soviet Union, was launched on April 19, 1975. Thereafter Rohini in 1980. Thereafter Polar Satellite Launching Vehicle PSLV in 1990s. Then India's first solar observatory mission, which are recently we are encountering, that is known as Aditya L1. So we can say that ISRO and India is working a lot towards the having the development in the Indian space and the outer space also. But the most important aspect is there, what are the legal activity, what are the legislation were available for those. So at present, if we talk about, India is a party to all different treaties which are available. But here I would like to take first of all the important name of the United Nations Committee on Peaceful Use of Outer Space, which is known as UNCOPUS. UNCOPUS was formed in 1959, and if we talk about what are the different task was done by the UNCOPUS, then we have to move towards the basic framework of international space law, which are available. So, UNCOPUS, which we talked recently, it propounded five international treaties, and these are generally not was the treaties, but the five sets of principles which were working for the uh, uh, ensuring the peace in the outer space. So these five international treaties, which have thus been negotiated and drafted under the aegis of UNCOPUS. First one was the Outer Space Treaty, that is known as, it was founded in 1967, and it was the foundation of international space law. So credit goes to this first treaty, signed in 1967. This treaty established principles such as the freedom of explored space, the prohibition of weapons of mass destruction in space, and the responsibility of states for damages caused by their space objects. The first Outer Space Treaty was done in 1967. So this was the treaty
Uh,
which was, yes.
your slides are not moving.
Okay, okay. Let me
Which
check.
side are you?
Let me check. Yes, on my screen it is giving, it is showing the right slide.
So now it has come to elements of outer space.
Yes, yes, that is.
Now right now it is there.
It is working right now.
Right now we
Okay,
can see this.
okay, okay. Is it visible elements of outer space?
Yes, sir. Now
Okay.
it is.
Yeah. So it was a treaty on principles governing the activities of states in the exploration and issues of outer space, and including the moon and different celestial bodies. And it was formed in 1967. And thereafter, uh, to elaborate on the Article 5 and 8 of the Outer Space Treaty, we had another treaty which was known as the Rescue Agreement, and agreement on the rescue of astronauts. It was relating to the rescue of astronauts, the return of astronauts, and the return of object launching into outer space, 1968. Let me tell you to the audience that it is the most important aspect, that what are the elements which are which are launched into the outer space by one country, then, and it is creating some disturbance in the outer space. Later on we'll discuss on that. So for rescuing all those problems, and for safeguarding all those problems, we got another treaty agreement, that is Rescue Agreement 1968. The next one is the Liability Convention 1972, because until 68 there was nothing was worked on the liability but the responsibility. And international law, if you are the student of international law, there is a great difference between responsibility and the liability. So that Liability Convention 1972, which was the next initiative by UNCOPUS, so it elaborates on the Article 7 of the Outer Space Treaty, and this Liability Conventions, which we call is in another word, the Convention on International Liability for Damage Caused by Space Object 1972. It is the right full name of this liability convention. So it is relating to the damage, and then fixing the liability of the particular state who did this activity, who was involved into this activity. Thereafter, then if we move further, then another convention or another activity was done, which was known as the Registration Convention 1975. So it was a convention on registration of objects launched into outer space. So for this 1975 treaty, which was another extension to the Outer Space Treaty, was fixing the registration, making compulsory registration towards the treaty parts. And the last one is the Moon Treaty 1979, reformed and elaborates on many of the provisions in the outer space, and it provides the agreement governing the activities of state on the moon and other celestial bodies, 1979. So so all these treaties, although these five space treaties constitute the most important part of international space law, it is not limited to this treaty. Apart from the above mentioned treaties, which I just discussed, international space law also consists of a growing number of international, multilateral, and bilateral treaties, resolution of the United Nations, writings of the eminent jurists, instruments issued by international organizations, customary international law, national legislations, policies and regulations, and court decisions. Further, the United Nations General Assembly has inter alia adopted the certain regulations concerning the law of outer space, generally on the basis of consensus among the states. So, if we talk about those resolutions which was adopted by UN, uh, few of them was that, for example, the declaration of legal principles governing the activities of states in the exploration and use of outer space, which was done in 1963 before the outer space activity. Principle governing the use by state of artificial Earth satellite for international direct television broadcasting 1982, because for television broadcasting we need outer space activities, so it is relating to that. Then principles relating to remote sensing of the earth from outer space 1986, principles relevant to the use of nuclear power sources in outer space 1992, and declaration on international cooperation in the exploration and use of outer space for the benefit and in the interest of all states, taking into particular account the need of developing countries in 1996. So we can see that these are the basic framework of international space law internationally. Then if we talk about, because if we are talking about the different elements of outer space law, then we cannot forget the contribution of India. So India is a party to all the five space treaty and has gradually emerged as a leading nation in terms of outer space capability. However, despite having accomplished indigenous launch capabilities, India is yet to put in place.
Sorry to interrupt. The slides are not moving.
Okay. Still, I'm working on the element of outer space law. I have not moved my slide. Is it visible?
Okay, sir, I will request you to put the screen on full screen mode, full screen. So the sides can appear on the full screen.
Okay. Just a second. Give me 1 second. Is it okay?
So press F key to show the screen on a full screen.
No, so I have already pressed that screen, that F5 screen, F5 button on my screen.
Okay.
And on my screen, it is visible full screen.
Okay, maybe work issues. Okay, fine, no problem.
Because on my screen it is showing full screen.
Okay, sir.
Okay.
Okay, sir.
Oh, so we were talking about the India's contribution. So at present, the legal framework of space activities is broadly governed by Article 51 of the Constitution of India, which primarily obliges the state to respect international law and its treaty obligations. So this is correlating to all five treaties. Further, Article 73 of the Constitution of India empowers the Indian executive to exercise its powers as are exercisable by the government of India by virtue of any treaty on agreement. So because we are the part of that agreement, so 73 is also applicable here. In addition, several policies have been formulated by the Indian executives in order to regulate their space activities, which if we call them, first one was the satellite communication policy in 2000, then revised remote sensing data policy 2011, then technology transfer policy of ISRO, and norms, guidelines, and procedures concerning allowing Indian parties to provide services, including uplinking of TV signal with Indian satellites. So these were the some aspect of the India's contribution towards the element of outer space law. If we move further, because we have clearly understood that what are the basic framework of the outer space law are working towards, and what are the contributions of India, then if we move further, is my slide moving now? I have moved my slide.
No, sir, it's not moving.
Just a second.
Sir, it's moved.
It's moved?
Yes.
Yeah. Okay, good. Yeah. So now, next is now we are going to talk about various factors causing disputes. So, what are the need of all these legislation? Because if dispute is not there, so it is inherent obligation on the part of all the member state to the five space treaty to match their domestic laws with the provisions of the treaties. Therefore, if we talk about how do dispute arises, so we will discuss about the space pollution. The most important aspect is the space pollution, where space pollution, if we categorize into the different categories, then space debris is one of them, the asteroid mining is one of them, space tourism is one of them. So I will discuss all these things in detail. So if we talk about the space pollution, so several factors are there which might affects, which might create a threats to the space, and which can create the pollution in space also. Even we talked about this pollution on the earth only, but in space we were creating the several space pollutions, like when we sent launch different satellite vehicles over there, and there are certain accident happens, or meteoroids collides to each other, then so many pollutions things, debris are going around, and it might create a big problem to the space and to the countries also involving in the space activity. So first one is there is the air problem. So the a lack of air in space creates vacuum, which is considerable in terms of this, and which might create the dispute among the cities. Second one, the task is that the main important aspect is the variation in temperatures also. So if an astronaut's back is facing the sun and not the front, the temperature difference can be as much as 275 Fahrenheit. So we can easily presume that how astronauts are facing the problems because of these debris. And to protect the astronaut from the sun, their spacesuits must have heavily shielded face plates. So that's why their astronaut suits are designed in a very separate manner. Then another important space debris if we talk about is the meteoritic impacts. So there are numerous extraterrestrial objects which are roaming around in the Earth's orbit or the outer space orbit, encountered in space, and debris which gets captured within the orbit of a planet. Though the chances of a collision are very less, the possibility cannot be ruled out, posing a great threat. And we have seen in earlier in our in past that several times we found that some meteors touch the Earth's boundary also, and they create a great disturbance on that. The next one is radiation damages and the lunar dust. So the exposure to radiation from space could be hazardous to human health, who are just like we can talk about the astronauts even as well as the people on the earth also. So these radiations have the capability of modifying and destroying data, because we are using the space for transportation of communication, finally making all the instruments in space inoperative, thereby making human survival challenging. We are protected from harsh radiation due to Earth's atmosphere. So definitely Earth's atmosphere is stopping these radiations, but we can understand that why CFC, the chlorofluorocarbon, which is causing the depletion in the ozone layer also. And not only that is essential, and that is responsible for the ozone depletion, but the rockets which are sent by the different country to the space, their temperature, their different activities also affects the ozone depletion, even the 1% of that, but it is affecting this thing. Then next one is the other factors for gravitational fields also provide the problem to the astronauts and different space activities. So space travel requires transition from one gravitational field to another, where the forces vary considerably. We are all known for the gravitational aspect on the space as well as the earth, so it varies a lot, and this alternation affects spatial orientation, balance and leads to motion sickness. And in the absence of gravity, there occurs a loss of mineral from the bones, and with the density and with and all these things, who which is affecting all these things, the space debris, because the space debris and asteroid mining is a recent startup by the different international countries, but it is affecting all these things, the temperature variation and different things also, and alteration in the fundamental performances of the astronauts also, and the different satellite we have sent to the space activity. All these things are affecting our space, creating the space pollution and affecting the information and other activity which have been run by the different countries on that. So, and if we talk about the space pollution, moreover, then we cannot forget to here on this platform to remind the different accident happened in the space. And for example, recently one of our astronaut, the India-based astronaut, is still in the space, and we are trying to get them on the Earth. But so if we talk about the different accident in the space, Soyuz 1 parachute failure was the first one which we cannot forget in. And then thereafter, one January 28, 1986, STS F1L space shuttle Challenger disaster was there. And next one is STS 107 space shuttle Columbia disaster in 2003. Then, so what are the learning from there? That definitely such kind of accident if are happening and by the one state, and they are creating the disturbance to the outer space of other country, then definitely dispute will arise. So what kind of actions could be taken? So in such dimensions and such regime, what kind of action could be taken? So the member countries and the countries who are involved in this space activity should ascertain that all nations are equally protected from the risk posed by overflying space system. So definitely we have to limit our space flying activities. Then we have to ensure that a space system are built and operated in accordance with minimum prescribed safety rules. Because if we are sending this our space vehicles into the space without following the minimum safety system, then definitely it will create the space pollution. The endeavors must be to prevent collision during launch and other operations. So we have to triply sure that our vehicle is totally ready for launching. Then we have to ensure the protection of the environment from chemical, radioactive, and debris contamination, which are most important part, which is contaminating, which is polluting the outer space at large. Then ensure that mutual aid provisions for space mission safety emergencies are progressively agreed, developed, and provided without restrictions anywhere on the earth and in outer space. So we have to follow the treaties. Different treaties have been made for all these activities. So these are the different actions and range of outcome for different kind of disputes which could be taken. My slide moved?
Yes, sir.
Yeah. So it shows that what are we have come to this point, that what are the how, that's why we need an effectiveness of various mechanism. Even we are having the different mechanism we discussed recent in my last slides, like international treaties and India's contribution towards it. But definitely something is more, because it takes time, so something speedy must be there. So for getting the speedy, what we have to do is, what we have to need it, I would take the inclusion of alternate dispute settlement mechanism, which is recently being the part of every dispute mechanism, and which has been recognized internationally. So first one I would focus on to resolve such kind of dispute is the consultation. Consultation and prior notification is one of the most useful dispute settlement and conflict avoidance techniques. So definitely the member state must be the part. I would suggest that they must be the part of, even it was suggested by the international, different international framework, that consultation would be taken before doing certain activity, and then you have to consult your neighboring states and the states which might be prone to the this kind of activities. And one of the most useful dispute settlement and conflict avoidance techniques, which we say, this procedure requires a party that is considering adopting a policy or taking an action that might adversely affect another party to inform the other party of its intervention intentions and to discuss the matters beforehand to avoid any potential dispute arising. Then, if we are focusing towards the consultation, then what could be the advantage of consultation? We have to think about it. The first advantage could be the permits parties to identify and attempts the settlement of potential problem at an early stage, because this is especially vital in dispute arising from space activities, where the early resolution of any potential dispute avoids the escalation of the problem into an international conflict, as well as soaring political and economic cost. Second advantage might be consultation may give the party proposing action a better understanding of how its proposed policy may adversely affect the other party. And third one is consultation provides an opportunity for the affected party to make measure of its own to avoid or reduce the potential harm. So the next one is, in terms of alternate dispute resolution mechanism, is the negotiation, which is widely popular for solving different international commercial disputes. So it is the method by which most international disputes are settled, and ICJ also affirmed the fundamental character of this method of settlement in the North Sea continental shelf case, which generally is very popular in the international law study, endorsing the opinion of its processor, the Permanent Court, in 1924, and even in the different hijacking case, the negotiation is also the part of that, which is more popular to resolve the dispute without going to the courts or taking much time. Then, what are the regions that attracts parties to the use of negotiations as a method of dispute settlement? So different regions, we can quote certain regions here, like negotiation is a low risk mechanism for dealing with dispute. Parties retain maximum control over both the process and outcome, since they preserve the option to walk away from the negotiation and not agree. So win-win situation is always there. Negotiation is most likely to result in the most accepted and stable outcome. It favors compromise and accommodations between the parties rather than a zero-sum win-lose situation. So these might be the we can quote here some advantage of the negotiation. The next I would focus on the mediation. Mediation is especially expedient when the animosity between the parties is so great that direct negotiations are unlikely to be successful. So definitely we will move towards the mediation. So in mediation, a third party intervention to reconcile the disputant claims and advance a compromise solution. So mediation might be the next option for lessening the dispute settlement, especially the outer space, because we are taking on the same platform to the two party contesting party. So mediation might be the one of them. Then next is conciliation. Conciliation under the conciliation rule of International Chamber of Commerce (ICC), the distinction between mediation and conciliation makes no practical difference. Generally, both looks like same, but this is because the conciliation rules leave it to the conciliator whether or not to make settlement proposals. So conciliation is more, in terms of nature, in terms of process, conciliation is more confined. And conciliation as a method of dispute settlement has gained recent popularity, with the prominent commissions investigating for that. For example, if we talk the violence accompanying East Timor's independence referendum, NATO's bombing campaign in the former Yugoslavia, and the spate of violence in the Middle East, Israel and Egypt also turned to conciliation in the Taba dispute. So In international dispute, conciliation is taking part and solving the problems easily. So it has certain advantages also, like conciliation is more flexible than other binding third party dispute settlement mechanism. Conciliation allows compromise to be made more easily because there is facilitator who is working towards the conciliation. Conciliation allows party to avoid losing face and prestige by voluntarily accepting the proposal of the third party. So it is another advantage of this one. So after conciliation, arbitration is one of them. So every country, after the advancement of this technique, arbitration, even India is a part of that also. India is also propounded its arbitration act in 1996, and different countries are having UNCITRAL's model, and they are following the arbitration models also. So they are working on that, and arbitration is the next important aspect which has been mooted vigorously as the most suitable means of dispute settlement for disputes arising from outer space. The strength of arbitration might be like it results in final binding decisions, although several other methods of dispute settlement can help parties to reach a settlement. Most of them rely on party bona fide and cooperation to be enforced. There is international recognition of arbitral awards, and New York Conventions and the Geneva Conventions are the two instruments which are supporting the arbitral awards, international arbitral award. Then arbitration is a neutral process. It's in arbitral proceedings, parties can put themselves on an equal basis in six essential factors. Number one is place of arbitration, then language, then applicable procedural law, then applicable substantive law, and nationality and legal representation. So these are the certain important factors of the arbitration, and arbitration is known for its speed and economy, and arbitration preserve confidentiality. So after arbitration, the next tools which I would focus on is judicial settlement. So if this all methods which I discussed, from consultation, negotiation, mediation, conciliation, and arbitration, if all methods of settlement fails to resolve the dispute, then some treaties provide for judicial settlement. This results in a third party decision legally binding upon the parties. Adjudication is performed by a standing court. Among the few permanent international court and tribunals, the International Court of Justice is without doubt the most important for available tools for judicial settlement. So we have seen that all these different tools are available. Apart from having the different treaties, for the enforcement of those treaty, the contesting party may move towards all these different activities. After this, so now we have come to the end of our today's topic, and now I would move towards the summing up. So in summing up, we have seen that starting from the 1957, the Sputnik, starting from the space age, and now we are working. We have seen in India. Our ISRO has worked towards the launching of L1 Aditya for the sun, catching the activities of sun, and for we for any outer space dispute, if it arises because of the different space pollution spreaded by the one country and another countries fighting for that, then different treaties we have talked about today, the different five treaties were there, and apart from those, different other frameworks are available. And if we talked about the India's contribution towards working, how India is contributing towards resolving or such kind of disputes, and how India is recognizing those treaty under our land of the law, that is the supreme law. Constitution of India is also supporting the treaties under Article 51 and Article 73. And we have seen that different, apart from this different mechanism we talked about, like starting from the consultation, then negotiation, then mediation, arbitration, conciliation, and then judicial settlement. So in summing up, we can say that even space activities are growing day by day, but we every country, even few countries are having their own space legislation, but the call of the time is that India must have its own space legislation. Even something has been done, space laws, something, some activities was done in 2017 which are under consideration also, but we must have a solid legislation for dealing with such kind of activity in the on the same front with the international framework. So with this, I come to the end of my today's lecture. Thank you so much.
Thank you so much, sir. Now, so with your permission, can we open the forum for questions if there are any questions? Shivam has raised his hand. Shivam
Yes,
Gupta.
Good morning, sir.
good
Am I
morning.
audible, sir?
Yes, you are audible.
Sir, thank you so much for such a wonderful session, sir. Firstly,
Yeah,
sir, secondly, I want to ask that India has made a space policy in the 2023, but still the lacuna of that law part, all that legal part, still
vacant.
prevails in India. So sir, as per you, how these international law, we already know that international law are being the weak law. So how you think that enforceability part of foreign treaty can be imposed in India? Apart from that, that India needs a special law, I think so. So,
Yeah. So, as I told you in my lecture, that we have to focus on the supreme law of the land, that is the Constitution of India. And if you see that during my presentation, I focused on that Article 53 and Article 73s are there. And these are the, providing the bindingness of those treaty up to until we are having our own specific laws relating to the dispute settlement in outer space, all these problems, we must focus on, we must take the help of all these things, and definitely they will help us a lot.
Thank you, sir. Thank you, Shivam. Any more questions? The participant, the forum is open. Okay. Sir, this was a very interesting session on space law. As India is moving further and further, and we all know that from our very ancient past, India has had or used to be space masters, be it scriptures or maybe later on in their inventions and everything. And later on, many Westerners, they took up many Indian concepts from our scriptures, and they discovered many mysteries about the space. But with modern Indian space ventures like Chandrayaan, Mangalayan, and now the venture towards the sun is, I don't know, maybe endless opportunities are there for India. And and space law and arbitration, I think it's a very unique and chic field where the researchers have a lot of scope for research and study as well. Thank you so much, sir, for explaining this so well, and even starting a conversation and discussion on such a wonderful topic. Thank you so much, sir. And since there are no questions anymore, with your permission, we'll end this session.
Thank you, Dr. Somi, and definitely you have started a very good initiative, and taking all the legal aspirants and the law aspirants on the same front and same platform. It's very essential, and the topic which I chosen, I thought that it's a call of time to raise some volume on this particular topic, because lots of disturbance are happening in the outer space, because everybody is working, everybody is talking about the India and Earth. So we are not talking about the space.
Yes, sir.
So thank you so much, Somi, and it was nice audience we are having, and thank you so much.
Because Vidivata, we have an open forum, and we expect anybody who wants to join our lectures are welcome. We do not restrict ourselves towards just law students, but others from any other social science field or science field can join, so that the our lectures and the research material and the expertise and expert people like you who speak on such topics, everybody should know such kind of discussions, and everybody is welcome.
And it's evident. I think recently I have gone through that. It's evident that Vidhivarta is working a lot towards spreading such knowledge, and I have seen that you are offering some internship also to the law student. That is most important one, because law students are roaming around for internship, and Vidhivarta is playing a very important role in that. So I must congratulate Vidhivarta for starting such venture, and I wish good fortune for the Vidhivarta in coming future. With finger crossed, and come with the flying colors. Thank you, Dr. Somi. Now you can wind up with this.
Thank you, sir. Thank you so much, sir.
Thank you everybody for being a good listener. Thank you.
Thank you, sir.
Thank you, sir. Thank you.